Good morning. I'd like to call to order this hearing of the Bethany Beach Board of Adjustments. We're here to consider an application submitted by Brennan J. Bickle of Element Design Group for property owners Patricia and George Magan for the property identified as Block 127, southern 27 feet of lots 2 and 4 at 65 South Atlantic Avenue in the R1 Residential Zoning District of Bethany Beach. Applicant seeks variances from Section 425, Zoning Attachment 3, Appendix 3, Table of Dimensional Requirements, to permit the removal of the existing dwelling and construction of a new dwelling. In particular, the application requests a variance from Chapter 425, Attachment 3, Appendix 3, Table of Dimensional Requirements for reductions in the required minimum for side yard setbacks from 7 feet to 3 feet on each side. The side setbacks for the existing structure are 0.5 feet on the south side and 3.3 feet on the north side. The applicant previously submitted an application seeking variances for the side yard setbacks, but in addition, variances from Chapter 425, Attachment 3, Appendix 3, Table of Dimensional Requirements for exceeding the maximum lot coverage by building permitted. Secondly, a variance from Attachment 5, maximum lot coverage, percentage trade-off chart for R1 and R1B district for the number of floors permitted. And thirdly, a variance from Attachment 5, maximum lot coverage.
Mr. Chairman, that was the previous case.
I know that.
Okay.
I'm describing the earlier case.
Okay.
From Attachment 5, maximum lot coverage, trade-off chart for R1 and R1B district for roof pitch. A hearing on that application took place on August 7, 2023, and a written decision denying each of the requested variances was issued on November 9, 2023. To facilitate the preparation of the transcript in this case, I would ask each of the board members present to state their names. My name is Michael Loftus. I am the chair.
My name is Sherwin Weinstock.
My name is Jack Gordon.
My name is Rich McHugh.
Thank you. As a first order, we'd like to address the publication requirements for this hearing. Susan, do you swear or affirm to tell the truth during this hearing?
I do.
Did you or the town place a notice of this hearing in public places?
Yes, the notice was posted on December 1, 2023, at 2 places: at the Boardwalk, the library, Town Hall, and the post office.
All right. And did the town cause a copy of the notice to be published?
To be made,
To be published in newspapers?
it was published in the Wave on 11/28/2023, and in the Coastal Point newspaper on 11/24/2023.
Okay. And do we have copies of those?
Yes, we do.
All right. Those will be marked. And did the town send by first-class mail addressed to property owners within 200 feet of the subject property a copy of the information required to be posted on the property?
Yes, the notice was mailed December 1, 2023.
And lastly, did you place notice of this hearing on the property at 65 South Atlantic Avenue?
Yes, notice was placed on December 1st, 2023.
All right. In the absence of objection, I find that notice of this meeting has been posted and published consistent with Section 425, Part 107 of the Code. The posted public notice is to be marked as Appendix 2, as Applicants 2. The newspaper proof marked as Applicants 3.
Yes.
Let me describe for you the order of events as we proceed with this hearing. All testimony will be sworn. Participants, once sworn, remain under oath until we finish the hearing. There is a transcript being made of this hearing, and therefore speakers should be at the podium using the microphone when they're recognized to speak. We'll begin with a synopsis of the application by the town building inspector. We'll then have questions by the board, identification of the parties and those wishing to make a statement. Presentation of the applicant's evidence will then proceed, and we will have questions and cross-examination of the applicant's spokesperson. We have received 3 letters expressing support for the application, which will be marked as supporters 1, 2, and 3. We have reviewed those emails, and they will be considered. Are there any people here wishing to make statements at this hearing in support of the application? I see none. We'll then proceed with presentation of any opponent's evidence, with questions, cross-examination, and an opportunity for opponents to present additional testimony. We'll then have statements from members of the public opposing the application. We have received 6 emails in opposition to the application, which we will mark as objectors, and then the name of the objector and the appropriate numeral for objectors. We have reviewed those emails, and they will be considered. Are there any here wishing to make statements at this hearing in opposition to the application? I see one. I ask that you, I'm sorry, I see 2. I ask that you go to the young lady at the table back there, Christy, and write your name down as someone wishing to make such a statement, and at the appropriate time, we will call you. At the close of all evidence and public statements, the applicant may give rebuttal evidence followed by closing arguments. Finally, the board will deliberate and may vote if we finish deliberations today. However, such a vote is only to be considered part of preliminary deliberations. The final decision approved by a majority of the board is the official position and decision of the board. Appeals to Superior Court must be made within 30 days of the filing of the decision with the town. With that, Susan, would you please present your synopsis of the application?
This is Board of Adjustment 2023, Case 3, for 65 South Atlantic Avenue, Block 124, and the southern 27 feet of lots 2 and 4, for Patricia and George Magan. The applicant, Brennan Bickle of Element Design Group, for property owners Patricia and George Magan, is requesting a variance from Chapter 425 Zoning, Attachment 3, Appendix 3, Table of Dimensional Requirements, to reduce the required side yard setbacks on each side from 7 feet to 3 feet. His proposed plan shows the side setbacks to be 3.67 feet on the south side and 3.34 feet on the north side. And I believe I've got that backwards, because I just looked at it. So it's side setbacks to be 3.367 feet on the north side. No, that's correct, on the south side, and 3.34 feet on the north side. This is a second request from Mr. Bickle and the property owners for this property. They originally came before the board in August of this year, last year, requesting variances from required side yard setback, lot coverage, roof pitch, and required maximum permitted area of a third floor. The board voted to deny their requests. The property is an undersized lot of 2,433 square feet, 90 feet long by 27 feet wide. Lots in R1 zoning district are typically 5,000 square feet in size. This lot is less than half the required size. It is located in the flood zone AO with an elevation of 2 feet. The lot is improved with a 3-story single-family dwelling, shed, ground-level decking, and a concrete driveway. My records show that the existing dwelling is a 3-story single-family dwelling with 4 bedrooms, 2 full baths, 2 half baths, a second-floor room, a living room, and kitchen. The total square footage of the habitable space is approximately 1,546.5 square feet, and the existing lot coverage is approximately 682.16 square feet, including the existing shed, or 28%. The current setbacks are 20.2 feet front, 0.5 feet on the south side, 3.3 feet on the north side yard, and approximately 29 feet rear yard. The existing shed is 2.2 feet from the rear property line and 0.9 feet from the side property line. The applicant is proposing to demolish the existing dwelling and all other improvements. He is proposing to construct a new 2.5-story dwelling with 4 bedrooms, 3.5 baths, an open-plan living, dining, kitchen area on the second floor, a screened porch, and front and rear decks. The total habitable space is approximately 2,379 square feet. The total area of decks and screen porch is 441.9 square feet. The only variance required is one from Chapter 425 zoning, Attachment 3, Appendix 3, Table of Dimensional Requirements to reduce the required side yard setbacks on each side from 7 feet to 3 feet. Attached to the memo was a copy of that Appendix 3, a copy of the survey on file, and the applicant's submittal. Any questions?
Yes. The statement, the only variance required is one from Chapter 425 zoning, Attachment 3, Appendix 3, Table of Dimensional Requirements to reduce the side yard setbacks. That means that you have reviewed the plans and determined that in all other respects, including front and rear setbacks, height, lot coverage, density, bulk density restrictions, etc., have been satisfied for the proposed structure.
Yes.
All right. have no further questions. Sure.
Thank you, Susan. The current lot coverage is 28%, is that what, am I interpreting that properly?
The current lot coverage is approximately 28%.
Do you have an approximation of the
The
proposed
proposed
new structure?
is almost 40%. 40% would be 973 square feet, and they are proposing 970. So they're right there.
And when was the existing structure built?
I'm not sure of an actual age of it, but it's pretty old. I don't recall.
Okay.
And it had lots of additions to it, so how it originally got there, I'm not sure.
Okay, thank you.
No questions.
Rich.
I just have one. Susan, with this particular house as it's currently sitting, had there been discussions about the height of the house in terms of flooding concerns and having to do something about that?
I think I had a discussion with them at one time concerning elevating the house because, to where it should be for base flood elevation plus freeboard, and I believe they looked into it.
And one of the ways to address that would be to raise the house as it currently
Would be to, basically lift the house high, build a new foundation under it, and set it back down.
Okay.
This, if possible.
That was more of a suggestion than a requirement.
They were, well, it's not a requirement, but if you can do it, it helps you with your flood insurance and everything. I think they were looking at first working on correcting that, but I think that the cost of that and how it would be done may not have been
Okay.
found easy or feasible.
Thank you.
I have a
Yes.
question I was going to ask that. Would you require a variance if they wanted to bring it within flood
No.
requirements?
Not when they're doing something to meet the FEMA standards, we don't require a variance. So if they had to raise it to the base flood plus the freeboard, they would be permitted to do so in place.
Thank you.
Any other questions from the board? Okay. May I ask who will be speaking for the applicant? Please approach the podium. Please state your name and local address.
My name's Brennan Bickle, architect at Element Design Group, 115 West Market Street, Lewis, Delaware.
Thank you. Please proceed.
My name's Brennan. I represent architect for Mrs. Pat Megan. As Susan stated, we're seeking a variance for the side setbacks to allow us to go within 3 feet to the side property lines. The existing lot is 27 by 90. If we would abide by the setbacks, it would allow for a house that is 13 feet wide. We asked for the variance to get a house width that can accommodate Mrs. Megan's family, get reasonably sized spaces, bedrooms and bathrooms to not only accommodate Mrs. Megan and her family, but also aging in place, universal design, and the spaces that are required, the sizes that are required for spaces to allow for that. The existing house is currently 23.3 feet wide. We are asking for property side setbacks that would allow a 21-foot wide house, and we currently have a 20-foot house designed. The reason for the 20-foot house design is that we have stairs and elevators for vertical circulation, and then we have a hallway, and to get that adds up to a little less than 7 feet, and then that only leaves like 6 feet for other spaces beside that. So we lose a lot of space very quickly just to get the required, circulation. In addition to this, if we abide by the setbacks, the maximum lot coverage we could even get would be 28% for the lot. This would suggest, to us, it suggests that the current zoning code isn't necessarily written for this lot if we can't even get to the trade-off chart, which is that it starts at a 32%. And we would only have a maximum of 28% allowable. Or not allowable, but just by virtue of the setbacks. So with that, Mrs. Megan would like to say something. Is that okay for her to talk in this presentation, or is that in support?
It is okay for her to speak, but I have a question, and others may as well, of you. You submitted, along with the application, some plans for the proposed structure. Is that correct?
Yes.
And I'm not asking you to go through those in detail, but I have reviewed them and compared them with the plans submitted with the initial application.
Mm-hmm.
Could you describe briefly whether these are modest changes that you made,
Mm-hmm.
or a complete rework? How would you describe them?
I would describe it as a complete rework from the original design. The original design was asking for a full 3-story house. This one, we're asking for, we're basically meeting all the zoning requirements other than what we're asking for the side setbacks. We're meeting lot coverage at 40%, and we're meeting, and within that 40%, there are requirements such as we have to maintain a 512 pitch. We are maintaining that 512 pitch. We have to have a 2.5-story house. We have a 2.5-story house. I believe those are the two big ones. And maybe and we're also going back 22 feet from the front. I think that's another requirement, an extra 2 feet just if you're in that 40%. So I would say from that first plan that we presented in August, this is a very significant redesign where we made spaces quite a bit smaller, reworked how the floors worked. We brought the living space from the 3rd floor to the 2nd floor, and now we have just a half-story kind of bedroom loft area up on the 3rd floor, which is technically the half-story. And then, so it was, like I said, a significant redesign.
All right. Thank you. Sherwin?
Nothing at this time, but thank you.
Thank you.
2 questions. The side of the lot, the north side, where the house is right now, how close is that to the property line of the adjacent properties on the north side? Is that in the 3-foot area?
From that side, we currently have a 3.3 setback, 3.34 setback from that side property line.
So in other words, the side of the house per se would be in about the same position?
Yes, exactly the same position.
Okay, the other thing is that side of the house backs up to the backyards of the 2 houses on Maple Avenue that the lot is adjacent to?
I believe, yes.
Okay, thank you.
In the design of the new house, has there been any consideration to flooding concerns along the two side yards in terms of preventing flooding that would affect your client's residence or the residences on either the north or south side of that residence?
In terms of the drainage, we will be meeting the code in terms of pervious versus impervious area, and there, because there's, now the added, we meet the lot coverage for the house, and now we're going to be looking at now we look at the pervious versus impervious for the driveways and patios. And we are currently within that, for drainage, we are currently within that requirement.
Okay, thank you.
Thank you. Ms. Megan, if you... Good morning.
Good morning, everybody.
Please state your name and your local address.
Okay, my name is Patricia Megan. My local address is 65 South Atlantic Avenue here in Bethany Beach.
Thank you very much. Please proceed.
Okay. After the last hearing, my architect and I heard...
Excuse me. I've been reminded. I've forgotten once again to swear you. Do you swear to tell the truth in this proceeding?
Yes, I do.
Thank you.
Okay.
Sorry.
That's okay. After the last hearing, my architect and I heard the board loud and clear that we needed to be more in compliance with the building codes, because we definitely don't want to set a precedent that others could use as an excuse to overbuild on their lots. So we went back to the drawing board and focused on the direction of eliminating three of the four variances. So that left us with only one variance that is critical to allow us to rebuild, and that is the 3-foot variance on the north and south side of my property. What I did this past month was send out an update to all the neighbors within the 200 feet of my property, letting them know that we revised our plans in accordance with the comments we received from the board at the last hearing. Since some of the neighbors are fairly new, I gave them a little background on my family's history with the cottage, especially since my family has been there as probably one of the longest people in the neighborhood. There's a couple other people that have been there longer than my family. I even sent the letter to those people who sent their emails protesting at the last hearing, just to let them know what we're trying to accomplish. We're moving on and trying to build a reasonable house that fits in with the neighborhood and fits in with Bethany in the 21st century. I want to kind of comment that the lot was, many years ago, probably back in the 1950s, it was approved by the town of Bethany. And the previous, as we heard at the last hearing, the next door neighbors, her father, did not purchase the additional lot, and so therefore the original owner decided to make it a separate lot and sold it separately. And so this is something that the town approved, a legitimate legal lot. And so I feel at this point I shouldn't be penalized for what transpired back then. And again, we are asking for a minimum leniency on our property. The variance will not alter the essential character of the neighborhood, but enhance the neighborhood compared to my current house. I mean, I kind of feel I've got these big houses next door to me and on the other side of the alley, and then I've got this little house that kind of sits, there. And so we're trying to make it more aesthetically appealing and enjoyable. And we are requesting minimum variances necessary to offer relief. This property was, again, legally approved many years ago, and the lot is unique and rare in the town of Bethany. The lot is extraordinarily small compared to the majority of lots in Bethany. The exceptional practical difficulty was not created by me, so we're again asking for leniency and with this minimum variance. Excuse me. So I hope our new plans meet with the board's approval and that we can move on and rebuild a beautiful cottage in Bethany that's been home for us for approximately 70 years. I read the emails from the neighbors and protesting, and I can comment on some of their observations, their concerns, but I don't want to belabor the point unless you feel that it's necessary. But I just want to thank the board and hope you take into consideration this request. Any questions? Sorry.
Thank you very much. I have no questions. Sherwin?
Thank you. No questions.
No questions.
Okay.
Thank you very much. I understand we have two of the individuals who have opposed the application who wish to speak. Do you have any preference as to the order? Okay. I ask the gentleman on my left to please approach the podium. Please state your name and your local address.
Good morning. My name is Jonathan Ruckteschell. I'm at 114 Maplewood Street.
All right.
I've submitted written comments.
Excuse me.
Yes,
I don't want to forget again.
right.
Do you swear or affirm to tell the truth in this proceeding?
I do.
Thank you very much. Please,
Thank you. I've submitted written comments, and I understand you've reviewed them, so I won't go through them. The primary concern that I, and I think most of the neighbors have regarding the increase of the non-conforming use of this lot, which is a small lot, is the exacerbation of the current flooding and runoff situation that we have along the alley behind Maplewood Street and onto the adjoining properties. This is a significant increase in the non-conforming use of this lot. If the property had been destroyed by an act of God, the code provides that it would have to be rebuilt in the same footprint. I'm sympathetic to my neighbor and her desire to modernize the structure, and I hope that we can get a plan that does that without exacerbating the current problems that we have with respect to runoff and flooding and water. And with that, I'll stand on the written comments. Thank you.
thank you very much. Please state your name and your local address.
My name is Janie Switzer. My local address is 318 Wellington Parkway.
Thank you. And do you swear or affirm to tell the truth in this proceeding?
I do.
Thank you. Please proceed.
I have some comments and some questions. I am a homeowner of 4 properties in the past 8 years. I'm also a local business. I'm a builder. And we're not an engineer. We're not an architect. And we've managed to design and build within all the current variances 3 homes. And we're working currently on the design of a 4th. We have yet to request any variances of any kind. I did a cursory search of the county records for the lots that are less than 5,000 square feet. I don't consider it rare that they exist because along Atlantic Avenue, north and south, I came up with at least 20. Many of these are on alleys, and I'm concerned for the future if we allow these variances, which are becoming more common and more bold. How are our fire trucks going to get down the alleys? Or our emergency vehicles? If you have 3-foot setbacks, I just don't see how that's going to happen. If you've got 2 houses that have 3-foot side setbacks or back setbacks and they're on the alleys, how are you going to get an emergency vehicle down the street? The current design is right at 40% within inches, and drainage is a big issue in this town, and it's a major focus, and I don't know how, with a lot this size, with that coverage, that you can maintain the water on your property or shed the water where it needs to go, and it's not going to affect the street, the alley, the sidewalk. And I'm wondering about the height restriction. Is this new design fall within the height restriction on Atlantic Avenue, and what is that height restriction?
I believe that the building inspector has testified that the proposed structure does comply with the height restriction in effect for that area.
May I ask what the height restriction is?
Certainly.
The height is based on one of 2 things. It can be based on 31 feet from grade, or you are permitted to do 31 feet from the base flood elevation plus the freeboard. So in this case, it's an AO flood designation with a base flood of 2 feet, and so it would be 3.5 feet above the grade.
Okay.
And then you'd measure your 31 feet.
Okay, all right, thank you. Another major topic that this town has been discussing in the past year is the tree canopy. And I'm not sure of the trees that are on the lot currently, if they are considered trees or bushes. But I'm also just expressing concern about the tree canopy and maintaining that or considering that for the future, for this lot and every lot. It feels like, so I've been coming to Bethany Beach my entire life. I've been a homeowner for 17 years, and I feel like the town is becoming a high-rise community, and if we continue to allow these variances, we're going to be shaking hands with our neighbor right through the window. And it's just going to start feeling like we're just a bunch of high-rises. And again, there's at least 20 lots along Atlantic that are less than 5,000 square feet, some considerably, and unfortunately this is the smallest lot at 2690. So it's something to consider for people coming to in the future to ask for these variances, and we're setting a precedent. And again, I don't begrudge anybody a new home. That's not my point. But I just hope that these things will be considered, and will it change the character of of that area of town? That's it.
Okay. Your review of the size of lots along Atlantic, did you describe that as cursory?
Yes, what I did, I went on to the Sussex County public property records. And every property, all you have to do is either put in a name or an address. And it tells you all the information that the county has published related to a lot. So name of the owner, the address, where the bills go, square footage, permits, documents, anything that's the county has documented for a lot, and it's public, complete public information.
All right, and you said that there are approximately 20 along Atlantic Avenue that are less than 5,000 square feet?
That is the information that I gleaned from the website. And so my concern is if and that's only along Atlantic. And I didn't even look at every lot. I just started and just put in every address I could. And I got to a point where I said, okay, that's enough.
How many were less than 4,000?
I don't have those notes with me. There were at least several, that were less than 4,000. Half maybe, but I really, without that, going back and looking again, I might have that information at my seat. Is it okay if I go get it?
I'd rather you didn't.
Okay. Okay.
Um,
So I can't accurately say, but there were definitely lots that were less than 4,000 square feet.
Okay. Any recollection as to the proportion that were less than 3,000?
Very few. This one is the smallest, so very few.
Is it the smallest by a significant margin?
Probably.
Okay. I have no further questions. Sherwin?
No, thank you.
Excuse me.
Wait a minute.
Jack?
No question.
I just have one. The concern you have about the new design and the contribution to flooding concerns, is that largely because of the side variances being requested, or is it largely because of the lot coverage of the new design?
So when we've designed a house, we start from the roof down because we're keeping the drainage in consideration. And I can tell you from very recent personal experience that if you have anything that's remotely close to maximum or is even remotely questionable of being pervious or not, you are going to have to validate that, even if it's a few square feet. And this lot, I believe, the house was 970, and the available coverage was 973 square feet. So that's inches. And is there going to be a pervious driveway? That it hasn't even been applied for yet. Is there going to be a fence request? That hasn't even been applied for yet. And are those going to be require a variance? Drainage is another huge topic in this town. And where it's not the town's fault, people blame it on the town all the time. If you come to any of these meetings, which I do, I come to a lot of meetings, and I encourage all these homeowners to do that, because that's how you know what's going on in this town. And that's how you know how hard our town management and our board is working, and it's a lot of work. So the drainage issue, along with the trees, is a big issue that needs to be considered and talked about.
I'm still not sure I understand the answer to the question, though. Is the concern then the lot coverage, which is conforming, or is the concern the variance they're asking on the sides? Because I'm not
Well,
sure from your
with only 3 feet variance, I am concerned that they're going to have a place to drain their water. And yes, I am concerned that has to be an important issue addressed at the beginning and followed through on at the end. Because I see plenty of people around here that, I'm not saying this is the situation, but I see plenty of things going on that are asked for forgiveness later. And then it's too late. Are you going to tell somebody to take their roof off, or tell somebody to move their foundation if it's 3 inches or 6 inches off? I just want a lot of attention to detail and thought for the future to be taken into account when allowing these variances that are going to probably be requested in the future. We have plenty of empty lots. We have plenty of old homes that are going to be renovated. And we have plenty of homes that are bursting at the seams on their lot. So I'm concerned that shedding your own water or retaining your own water is a very important concern. And all the neighbors will tell you that. Everywhere, not just in this case.
Okay, thank you.
Thank you very much. There being no further parties that wish to address the board, we'll close the hearing at this time and commence deliberations on the application. As chair of the board, and in accordance with the board's custom, I will proceed first in our deliberations to review the legal standards we apply in deciding applications for dimensional variances and to offer my initial views. We will then hear from each of the other board members in order of seniority. The applicants seek the variances involved in this matter in order to allow the construction of a new dwelling on the lot that would reduce the risk of being damaged by flooding and otherwise afford the owners a modernized home. Strict application of the side setbacks would allow the structure to be only 13 feet wide. The existing structure is 23.3 feet wide. The proposed new structure would be 20 feet wide, possibly as much as 21, I guess, is the testimony. Under section 425-105D of the town code, in considering an application for a variance from a dimensional requirement, the board is directed to consider whether, quote, owing to special conditions, a literal enforcement of the provisions would result in an unnecessary hardship or exceptional practical difficulties. Close quote. Approval of the variance requires that the board find 4 specific standards are met. The first of those is extraordinary and exceptional conditions pertaining to the particular lot or structure in question. The applicant here maintains that there are extraordinary and exceptional conditions pertaining to the lot and structure in question because of the size of the lot. The lot is approximately 27 feet by 90 feet, while the typical lots in Bethany Beach, east of Route 1, are 40 feet by 125 feet, which permits a structure of 26 feet wide. The width of the existing structure, again, is 23.3, and the width of the proposed structure is 20. It does appear to me that compliance with the code setbacks of 7 feet would not allow sufficient space to construct a reasonably sized structure which satisfies the standard of an extraordinary or exceptional condition. The second requirement is that the application of the code to this particular lot or structure would create an injustice. Applicant argues that, as a practical matter, strict compliance with the code would create an injustice because it is not feasible to renovate or elevate the existing house, and 7 feet setbacks would only allow a width of 13 feet, while the proposed structure would be 3.3 feet less in width than the existing structure. I do agree that denial of the requested setback variances would create an injustice in these circumstances. The third element is that the conditions are peculiar to the particular piece of property involved. Applicants maintain that the conditions are peculiar to this property because of the size and shape of the lot. It does appear to me, considering all the evidence, that the small size is unusual in the area, even if not unique, and thus largely peculiar to the property. The fourth criterion is that a variance, if granted, would not cause substantial detriment to the public good or impair the purpose or intent of the code. I believe the evidence shows that the proposed new dwelling would be an improvement to the area rather than a detriment to the public good. The new structure would be narrower than the existing structure, with an aggregate setback of approximately 6 feet as compared to the current 3.8 feet. It also would improve drainage in the parking area with the use of pervious pavers, replacing the current concrete. Although there have been concerns expressed about the height of the structure, the proposed height is within the code height restrictions, and the bulk density requirements are also satisfied. I do not believe granting the requested variances would cause substantial detriment to the neighborhood or impair the purpose of the code. Concerns have been expressed about the impact of construction activities for the structure in terms of damage to surrounding properties and vegetation. These are understandable, but I view that as a matter that should be addressed with the building inspector if there are in fact any concerns that develop in those areas. The board, in addition to the statutory requirements I just discussed, has to comply with the Supreme Court's holdings in the Quick Check case, that for an area variance, the focus is on the exceptional practical difficulties test. And the court articulated 4 factors to be considered. The first is the nature of the zone in which the property lies. In this case, the variances are sought for modifications to a residence in a residential zone, so it appears that this standard is satisfied. The character of the immediate vicinity and uses contained therein is the second standard. It does appear that the variances sought would allow modifications to a dwelling that would conform to the character of the immediate vicinity and uses. The third element, whether if the setback restrictions were removed, it would seriously affect neighboring properties. I note that there were 11 emails from neighbors in the area opposing the earlier application and no statements of support. For this application, there are 6 emails in opposition and 3 emails of support. For the reasons I have expressed, I view the proposed new structure as fitting in with the neighborhood in a manner that would not seriously affect neighbors in a negative way. I think that the proposed structure would be far preferable to a structure 13 feet wide. The last criterion is whether, if the restriction is not removed, it would create exceptional practical difficulty for the owner to make normal improvements. The quick check decision states that in this regard, the board should take into consideration whether, if the restriction upon applicant's property were removed, such removal would seriously affect neighboring property and uses, and whether, if the restriction is not removed, the restriction would create unnecessary hardship or exceptional practical difficulty for the owner in relation to his efforts to make normal improvements in the character of that use of the property, which is a permitted use. I do believe that denial of the application would cause exceptional practical difficulties for the owners and would impose a patent injustice, but that granting the variances would not seriously affect neighboring properties for the reasons I have described. With that, we'll move on. Sherwin?
Thank you, Mike. I'll be a bit briefer. First of all, I thank the owners for hearing our issues at the last meeting in August and for making as many adjustments as you did. Thank you. I believe the owners, the applicants, have justified the criteria, the 4 required criteria, and I agree with Mike. Not accepting the variance would be an injustice, and a new home is what helps the town, helps all of us. With that said, I support the application for the variance.
Jack?
I'm in agreement with the chairman with regard to his explanation as to why we should accept this variance. Obviously, the shape of the lot and the lot is probably one of the smallest in town, if not the smallest in town, in just looking at the map that we have on our website. It would be exceptional practical difficulties for the people if they had to build a 13-foot house. I think at one point, one of the letters stated that well, there are a lot of 13-foot houses in places where we have townhouses, and those are big cities, and we're not a big city. And so I think the idea of holding them to that requirement would be rather specious on the part of this committee. The problems were more or less particular to this property because of its shape and where it was, and the idea it is next to an alley on one side, and that, I think, sort of changes the nature of that property along with its being such a small size. I don't think in building a new house there substantially the same as the old house there, and I think I read somewhere that it was built in the 1960s, that it would be a detriment to the neighborhood to see a new construction essentially the same as the old construction. So I have to go along with the idea of approving this variance. And the last thing I'd like to mention is the fact that it comes up that things that this committee does are a precedent for future things that are accomplished. And everything that this committee looks at is looked at independently. The idea that we make a certain decision on this property does not mean that we will make that type of decision that the dam is broken and we have to make all these decisions. Each one stands on its own, so this is not any precedent that would hurt the current codes as we have them written, as far as I'm concerned, as part of this committee. So I am totally in favor of approving this variance.
Rich?
It's tough to be last to come up with new things to say, but I think that given the size of this lot, I think this matter really revolves around that. What makes this case so unique is the size and the difficulties associated with the size. And when I analyzed the 4 provisions of the town code and the standards in the Supreme Court case, that just stands out to me as the determinative factor. I also would agree with Jack as to the presidential concern here, because I don't think that is a concern because of the unique nature of the lot. Each of these cases is going to stand on its own. This one is unique because of the size, and others may present similar cases, but not identical cases because of that. Having said that, I would agree with the other 3 up here that I think the variance should be granted. I'm done.
As to the precedential value of these decisions, I'm glad you made that point, Jack. I mean, it is clear and has always been clear from the decisions of the board that they do not have precedential value as to what will be done in other proceedings involving other facts. So unless anyone has any further comment, I would entertain a motion on the application.
I'll make a motion to approve the application as stated for the variance.
Second?
All in favor? Aye.
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 Let the record reflect that all 4 members of the board have voted in favor. There necessarily being none opposed. The decision is and will be dealt with possibly in a written decision. The final decision approved by a majority of the board, in this case 4 members, is the official position. Appeals to the Superior Court must be made within 30 days of the filing of the final decision with the town. The board has 60 days from the conclusion of this hearing to issue a final decision. With that, at this time, 5 minutes after 11, this hearing is concluded. We have a second matter to be considered, but we're going to take a short break before we move on to that separate application. Thank you.
as fast.
I'd like to call to order this hearing of the Bethany Beach Board of Adjustments for the purpose of considering an application submitted by Sage Capital LLC, the property owner for the property identified as Block 123, Lot 20 at 118 Oakwood Street in the R1 Residential Zoning District of Bethany Beach, Delaware. Applicant seeks variances from Section 425 zoning, Attachment 3, Appendix 3, Table of Dimensional Requirements, to allow a hot tub and what applicant describes as a deck enclosure constructed without a building permit and in violation of the code requirements to remain in place. In particular, the application requests first a variance from Chapter 425, Attachment 3, Appendix 3, Table of Dimensional Requirements for reductions in the required minimum for the eastern side yard setback from 7 feet to 3.6 to 3.8 feet. Secondly, a variance from Chapter 425, Attachment 3, Appendix 3, Table of Dimensional Requirements for reduction in the required rear yard setback from 15 feet to 12.4 to 12.5 feet. And third, a variance from Chapter 425, Attachment 3, Appendix 3, Table of Dimensional Requirements, maximum lot coverage from 40% to 44.6%. Let the record show that 4 of the 5 members of the board are present. We will first address the publication requirements for this hearing. Susan, do you swear or affirm to tell the truth during this hearing?
I do.
Did the town place a notice of this hearing in public places?
Yes, the notice was posted in 5 public places. It was posted on December 1st, 2023, at 2 places at the boardwalk, the library, the post office, and town hall.
Thank you. And did the town place a notice for publication in newspapers?
Yes, it was published in the Wave newspaper on November 28th, 2023, in the Coastal Point, November 24th, 2023.
Did the town send by first-class mail addressed to property owners within 200 feet of the subject property a copy of the information required to be posted on the property?
Yes, the notice by mail went out December 1st, 2023.
And lastly, did you place a notice of this hearing on the property at 118 Oakwood Street?
The property was posted on December 1st, 2023.
Thank you. In the absence of objection, I find that notice of this meeting has been posted and published consistent with Section 425, Part 107 of the Code. The posted public notice is to be marked as applicants 2. The newspaper proof is marked as applicants 3. We've recently concluded a hearing in another matter, and at that time I described the order of events. We will follow that same order of events here. So Susan, if you would please, to review your synopsis of this application.
Sir, this was Board of Adjustment 2023, Case 4 for 118 Oakwood Street, Block 123, Lot 20, Sage Capital LLC, deck structure and hot tub spa. The applicant, Mackenzie Pete from Saul Ewing LLP, for property owner Sage Capital LLC, is requesting 3 area variances from Chapter 425 zoning, Attachment 3, Appendix 3, Table of Dimensional Requirements for lot coverage and side and rear setbacks. The property owners have also effectively removed 2 required parking spaces by surrounding the rear paved area, new paving with new trees. The hot tub also violates the town's regulations for pools and hot tubs found in Chapter 500, swimming pools and spas. In June of 2023, I was made aware that a large deck exceeding 12 inches in height with a hot tub spa on top of it was constructed at the rear of 118 Oakwood Street without permits and in violation of permitted lot coverage, side and rear setbacks, and in violation of the town's regulations for private pools and spas. It came to my attention when a neighbor called concerned about recently planted trees and their closeness to her fence. I contacted a person that I was led to believe was the owner, a Mr. Bill Baird. Mr. Baird told me that he had the deck and spa installed. Once notified of the problems, Mr. Baird did submit an incomplete application and photos. The names on the permit listed as owners that he submitted were Rebecca and Ashton Newhall. I told Mr. Baird that I could not issue a permit and that the deck structure and hot tub spa would have to be removed. His only recourse would be to apply for and be granted variances. I was then contacted by Ms. Pete on July 13th, 2023, letting me know that her firm had been engaged to represent the property owner. They first hired a surveyor to determine if any variances were needed. I got a copy of the new survey on August 1, 2023, which verified that the structures were in violation. Since that time, I have repeatedly requested that they file or remove the structures and finally advised Ms. Pete on October 31st, 2023, that if the variance was not filed for within 1 week, I would issue the notice of violation and they would be cited for any applicable fines. The application was filed November 7th, 2023. The property is a typical 40 by 125 lot located in the R1 district. The setbacks in the R1 zoning district for interior lots are 20 feet front, 15 feet rear, and 7 feet each side. The maximum lot coverage permitted is 40%. This lot has a total area of 5,000 square feet, and the maximum lot coverage permitted is 2,000 square feet. The property is improved with a 3-story dwelling completed in 2016 and front and rear paving and patios. My review for the permit for the dwelling calculated the lot coverage to be 39.67% or 1,983.17 square feet. My records also show that, based on the number of bedrooms that the house has, the property was to have 5 parking spaces and 2 spaces located in the rear. The permit on file for the rear paving identifies it as parking, but it is now being used as patio with no vehicular access. The new deck floor is elevated 16 inches above the patio with 2 risers. A seating wall 32 inches in height from grade surrounds the deck on 3 sides, except at the longer side where the hot tub extends through. The overall dimensions of the deck structure are 19 feet 2 inches wide by 10 feet deep by 32 inches in height. The total area of the deck structure is 191.67 square feet. It is 3.4 feet from the side property line and minimally 2.5 feet from the rear property line. The hot tub spa is 7 feet 8 inches by 7 feet 8 inches. It is located 6 feet 5 inches from the rear face of the deck, or 8 feet 11 inches from the rear property line to the outside face of the spa. It aligns with the outside face of the deck at the side property line, so it is 3.4 feet from the side property line to the outside face of the spa. Top of the hot tub is approximately 30 inches above the deck floor. Chapter 425, Section 425-2, Definitions and Word Usage defines residential building or structure as a building or structure, the principal use of which is residential. It defines as an accessory building as a detached building, not for habitation, accessory to and on the same lot with a principal building. A building or structure that does not have a wall and roof in common with the principal building by way of, but not limited to, a deck, walkway, covered or open, a buried foundation, knee wall, trellis, railings, or any form of fencing shall be considered as an accessory building/structure. Chapter 425 zoning, section 42510, accessory buildings, states that all accessory buildings shall be located within the rear yard space on a lot or plot which a principal building or structure is erected or is being erected, and shall be limited to 3 in number, including any detached garage. Accessory buildings shall comply with all safety and structural requirements set by the Bethany Beach building inspector. No accessory building or projection thereof shall be less than 5 feet from a property line. The table of dimensional requirements defines what is included in lot coverage in footnote A, which states that lot coverage would include principal and accessory buildings. Coverage is the maximum horizontal cross-section areas of the buildings on the lot, including covered arches and open deck porches built more than 12 inches above the ground, measured from the ground immediate below to the top of the finished floor, but excluding cornices, eaves, gutters, and chimneys. And any of the following where the topmost finished surface is less than 12 inches above the ground, measured from the ground. Outside steps, open deck porches, patios, walkways, driveways. Chapter 500, Section 500-1, definitions, contains a definition for spa or hot tub, which states that it is a pool containing water greater than 95 degrees, which is not emptied after each use, has a maximum depth of 4 feet, is large enough for the immersion of at least one person, and may have a high-velocity air and/or water jet system. Chapter 500, Section 500-3, private swimming pools, B, states that no part of a swimming pool, including but not limited to decks, aprons, mechanical equipment, and bathhouses, which is 12 inches or more above grade of the lot, shall be located in the yard areas as defined in Chapter 425 zoning. Section 500-3C states that a swimming pool, no part of which is 24 inches or less above the grade, shall not be considered in calculating lot coverage. Section 500-6, spas, states that spas shall meet the same requirements as private swimming pools. Lot coverage. The maximum lot coverage permitted on a lot in the R1 district is 40%. The deck structure is by definition considered an accessory structure, and by footnote A is to be included in the calculation for lot coverage. From my original calculations for the construction of the dwelling, the property is approximately at the maximum lot coverage permitted. Adding the square footage of the deck structure makes the total lot coverage 2,174.84 square feet, or 43.5%, which exceeds the maximum. Setbacks. The setbacks for an accessory structure is a minimum of 5 feet from any property line. The deck encroaches 1.6 feet into the required side yard and 2.5 feet into the required rear yard. Hot tubs and spas, due to the hot tub itself being greater than 12 inches in height, more than 24 inches above grade, it would be included in the calculation for lot coverage. The total area of the hot tub without the deck, 58.78 square feet, added to the area of the dwelling would also exceed the maximum lot area permitted. Other than the lot coverage issue, Chapter 500, Section 500-3B states that no part of a spa which is 12 inches or more above the grade of a lot can be located within a required yard. The spa encroaches into the rear and side yards. And attached to the memo was a copy of those sections of the code noted and a copy of the survey, copies of emails that were sent back and forth, the applicant's submittal, and photos of the deck and hot tub. Any questions?
Thank you. Yes. In the first and last paragraphs on page 1 of the report, you mentioned 2 required parking spaces. Is that something that this board needs to address?
I don't think so. I noted, just so that it's on the record, that that is something I noted in my investigation of this at this time I was looking at this, because it's not a dimensional requirement, but I wanted to just make it a note in this report.
Okay. On pages 3 and 4 of your report, you have photographs of the spa and hot tub enclosure. I could not discern from the photographs whether the area between the house and the hot tub enclosure is concrete or some other surface.
I believe it's all paved back there.
Pavers?
Pavers.
Pavers, okay. All right. And that's what we also see, the light-covered material there at the bottom of the picture on page 3.
Mhm.
Those are all pavers there.
Yes.
If the lot coverage variance were denied, would that automatically exclude the setbacks or require denial of the setbacks?
Without approval of the lot coverage, everything else is a moot point. This exceeds the lot coverage, and if they don't get that variance, it would have to be removed.
Okay. And when you refer in your report on page 2, in the bottom paragraph, to footnote A, you are referring to the note below the table of dimensional requirements, which reads, includes principal and accessory buildings, et cetera.
Yes.
Section 425.10, you note, and you provided us a copy of that, provides that no accessory building or projection thereof shall be less than 5 feet from a property line. We have a 7 feet side setback requirement that applies to this lot. Is this in lieu of that, or is this separate and independent of that? If you follow my question.
I'm not sure I do. The code allows for accessory buildings and structures to be within 5 feet of either property line, the rear or the side. And typically, that's where people will locate their shed. So if you think about it that way.
So,
But
so technically,
the main structure still has to be 7 feet and 15 feet.
right. Let me just check something quickly. So, in the application, at page 2 of the cover letter, describes the violations of the building or zoning codes. And item 2 is encroachment into the side yard, 7 feet setback. And the third item is encroachment of the hot tub and deck enclosure into the rear yard setback. Those should technically be addressing the 5-yard setback.
That's correct. After reviewing the code and the fact that they talk about accessory building also as accessory structure, and it's not connected to the dwelling itself, it can be looked at as accessory to it, and if the lot coverage was correct or approved, it could be within 5 feet of either setback.
All right. Well, by the way, I thought you did a very good job of laying it all
Thank you.
out in your synopsis, how the different code provisions operate
Thank
in the circumstances of this case. I have no further questions. Shirley?
Yes, thank you, Susan. That was very well done.
Thank you.
Who ultimately is responsible for getting a permit? The owner, the contractor?
Either one can, but ultimately, it's the property owner's responsibility to either get the permit or make sure they have a permit.
And I'm somewhere in here, do you know the contractor?
I've never been told who the contractor is. If it's in here, I don't know.
I saw his name once in
Okay.
here, but I'm just wondering if you're familiar at all with that individual.
I'm looking, I don't. All I see is the contractor.
It was, I saw it in here.
It's Exhibit B, maybe.
I saw it.
No, I don't know who did it.
Okay.
What's the point?
Yeah, exactly.
We'll find out.
Right, right. So, thank you for explaining about the parking. I wasn't aware of that. I
Yeah,
consider that.
the back paving was originally approved and was required as paving for 2 parking spaces.
Okay. So when somebody, like me, covers up our driveway, that's okay?
No, I don't know if they had, this was prior to the ordinance for ground covering, and so that doesn't apply here. So I don't know how big that area is back in there. So I don't know whether this was covering up parking or not, but I do know that they planted those trees completely all around, so there's no access to it.
Okay.
Can't get there with a car.
Okay. Well, thank you, Sue. Parking, especially east of Route 1 in the season is a serious matter. Good. Thank you. I'll be quiet.
No questions.
I have no questions right now.
Thank you, Susan. Who will be speaking on behalf of the applicants? Okay, before you start, is there anyone present who wishes to make a statement in support of the application? I see no indication of anyone who does. So, please state your name and your local address.
Sure. Good morning, Chairman, board members, Ms. Frederick. My name is Mackenzie P. I'm an attorney at the law firm of Saul Ewing with offices in Wilmington, Delaware, a local address of 34670 Villa Circle in Lewis, Delaware. I'm here.
Excuse me, you're a member of the Delaware Bar?
Yes, sir. I'm an attorney.
Thank you.
I'm here on behalf of Sage Capital LLC, the property owner of 118 Oakwood Street, Block 123, Lot 20 here in Bethany Beach, and the applicant in this matter. The property itself is located adjacent to a property that fronts on South Pennsylvania Avenue with the rear yard located behind that home, that primary structure, adjacent to this hot tub as well as the deck structure. And then to the rear of this property is the Episcopal Church there, if you all are familiar with the location. This morning I will be addressing the variance requests pertaining to the property. Mr. Bill Baird, who works for the family to clear up the connection there, that makes up the ownership interest in Sage Capital LLC, is also present this morning. By way of background, Mr. Baird, on behalf of the property owner, engaged a contractor who was a family friend to improve the property with a hot tub surrounded by a custom-built deck in the backyard at a cost of approximately $50,000. Pictures of those improvements are included as an exhibit in the application that was submitted, and you may wonder how this low-profile improvement costs that much. That cost is primarily associated with the use of Brazilian hardwood, which is known for its durability, density, and natural resistance to rot, decay, and insect infestation, making it an ideal choice for outdoor decking that comes at a higher cost than your standard materials that you might use for an outdoor deck. So after the improvements were constructed, the property owner learned, after a complaint from a neighbor, that the improvements were made without the necessary permit, constructed within the side and rear yard setbacks, and in excess of the lot coverage requirements. The applicant, and specifically Mr. Baird, acknowledge and regret the oversight of not seeking the necessary approvals prior to commencement and completion of the work. The confusion all had to do with what is a structure. However, it was an honest mistake that unfortunately can occur from time to time, as Mr. Baird believed, although mistakenly, that no authorization from the town for such improvements were required. Notably, as soon as the applicant became aware of the issue, they took steps necessary to initiate this variance process, which is the proper procedure to address and rectify issues like this. I will confirm that the history that Ms. Frederick stated is accurate. I'd just like to add to that Ms. Frederick and I did have some back and forth over the summer into the early fall. The timing by which it took to actually make the application has to do with a number of changes that were needed to the survey. We also wanted to actually have a new survey performed, which just in this market, it's still very busy down here. People are still very backlogged, especially surveyors. So moving on, the property owner sought to enhance their property with this improvement, a hot tub, to allow for the enjoyment of their property on a year-round basis. And the property owner contracted for the custom-built deck to allow for ease of entry and exit to and from the hot tub, to protect the hot tub from weathering and wear and tear, and to serve as a functional barrier defining an area in the backyard for the actual structure. We, of course, understand, and I've implored the point now with the applicant and Mr. Baird, the purpose and importance of setbacks and lot coverage requirements in maintaining the integrity and harmony of the community. We understand that there were letters of opposition. It seems like there are also people here today that may have some interest in this application. What I would note about the 2 letters submitted into the record is that neither point to any issue with the improvement itself, such as, for example, how the improvement impacts the neighborhood or surrounding properties. And at the conclusion of my presentation, I hope to convince you that the variances requested today meet the criteria for granting an area variance, but also that approving the variances do not undermine the fundamental objectives of these regulations, because the existing improvements are in line with the character of the neighborhood and will not adversely affect the surrounding properties. Moving on to the specific variance requests and criteria for granting a variance, the applicant seeks 3 variances that I will not summarize against for purpose of brevity. Of course, Ms. Frederick just ran through those in a detailed manner. As this board is well aware, years ago, the Delaware Supreme Court, in a case referred to as Quick Check, established the criteria for boards of adjustment to use in considering whether to grant an area variance. The test is one of, quote, exceptional practical difficulties, and the court outlined the 4 factors that the chair has said multiple times now and again for purposes of brevity. I will not read each of the 4 factors. I know that you're all familiar with them. Subsequent Delaware courts have explained further that these factors should be considered collectively and holistically rather than mechanically and mathematically. A review of each factor demonstrates that the variances requested here meet the Quick Check criteria for the following reasons. First, the property is in a residential zone, and specifically the R1 district, and the existing improvements, and specifically outdoor amenities, are consistent with the nature of this zone. Second, the immediate vicinity comprises primarily single-family homes, and the enhancements are in line with the character and aesthetic of the neighborhood and of improvements, and specifically outdoor amenity improvements a reasonable property owner might make to their home. Third, neighbors will not be affected, let alone seriously affected, by grant of these variances. The property owners have taken measures to ensure privacy and mitigate any potential concerns for neighbors. In terms of privacy, the applicant installed landscaping to serve as a privacy screen between the property and neighboring properties. In terms of aesthetics, the improvements are well integrated with the property and community. And the enclosure itself will help to maintain the appearance of both the hot tub, protecting it from weathering and associated wear and tear. I do know the issue has been raised with parking too, and that might be something that you're thinking about could affect the neighborhood. We've confirmed that the parking is code compliant, and we're happy to follow up with Ms. Frederick subsequent to this hearing to be sure that's accurate. And of course, if it's not code compliant, the applicant would have to seek a subsequent variance separate to the application that's before you today. And fourth, an exceptional practical difficulty exists where the requested dimensional change is minimal and the harm to the applicant, if the variance is denied, will be greater than the probable effect on the neighboring properties if the variance is granted. Here, if the variances are not granted and the applicant is required to remove the improvement, the applicant will suffer additional harm in the form of financial loss beyond its substantial investment in the improvement. In comparison, there are no known impacts on neighboring properties. Therefore, the applicant will suffer considerable harm if the variances are not granted, which will be greater than the effect on neighboring properties, if any, if the variances are granted. Even though the Delaware Supreme Court's ruling in Quick Check should be considered as controlling, the town's code also sets forth criteria for the board to consider. First, there are extraordinary and exceptional conditions pertaining to the particular lot or structure in question because of its size, shape, or topography. Here, the developable area of the property is limited due to existing improvements, significantly restricting the property's usable space and specifically usable outdoor space. I will add that the applicant has taken into consideration the option for relocating the improvements. However, due to existing improvements and specifically the presence of an existing porch that's shown on the survey that's included in the record, and the need for extensive modification to the backyard considering the existing pavers and other improvements, it is not feasible to relocate the improvements. Second, the application of the code to this particular lot or structure would create an injustice. In this case, the applicant relied on the expertise and guidance of Mr. Baird and its contractor to improve the property with the hot tub and deck enclosure. If the variances are not granted, it would mean that the owner's investment in time and money would be lost. It would not only, as I've stated, have to bear the financial burden of removing the improvement, not to mention a total loss of the approximate $50,000 investment in constructing the improvement, but also the loss of the intended benefit of the improvement, which is the reasonable enjoyment of the limited outdoor space on a year-round basis. Third, such conditions are peculiar to this particular piece of property involved. The improvement, and specifically the custom-built deck enclosure, are peculiar to this particular piece of property. And fourth, a variance, if granted, would not cause substantial detriment to the public good or impair the purpose and intent of this code. For reasons already stated, permitting the improvement would not cause a substantial detriment to the public good or impair the purpose and intent of the code. Considering the limited usable yard space for other outdoor activities, the applicant, by and through its professionals, sought to install the improvements to enhance their size-restricted outdoor space. Overall, the improvement is in character with the improvements of the residential zone, has no known impact on neighbors, and allows for the property owner reasonable use of their backyard. With that, I'll conclude my presentation. Thank you for your time, and I'll answer any questions that you may have.
Thank you.
You're welcome.
I do have a few questions. You mentioned that the owners did have did have a contractor who was a family friend.
That's correct. Well, yes, a family friend and a friend of Mr. Baird specifically, who was responsible.
All right. Was there a contract with that individual?
My understanding was that there was not a contract.
All right.
And the contractor is, I know this was a question that I'm anticipating is coming. The contractor's name is Bob Michael. He's certified in Maryland. He's not in Delaware. And again, all of this stems back to Mr. Baird and contractor's confusion over whether or not the improvements made met the definition of structure in the code.
Okay, and was the hot tub purchased from the same company that built the deck?
I'm not sure, but we can have Mr. Baird answer that question. If you want to keep working through your questions, I can have him come up at the conclusion.
That's fine. At page 3 of your letter,
Yes.
you make reference to, let me find it here. In item 2, character of immediate vicinity,
Yes.
you make reference to the prevalent use of hot tubs. Do you have any evidence as to the extent of that prevalence?
No, we do not, other than we believe it's common knowledge that hot tubs would customarily accompany a beach home in our area.
All right, and the statement above, in nature of the zone,
Yes.
where you state where a zone where the presence of hot tubs is not only common but also enhances the reasonable enjoyment. That again is based on that common knowledge.
That's correct, but I will say that on the ground in Bethany, a hot tub is like any other outdoor amenity. I mean, you've got porches, decks, patio areas, etc., which are commonplace in the community, and I would say a hot tub is like kind to those other improvements that property owners have already made in the community here, which I think are visually apparent from driving around the community.
Okay. And I have a question here about whether the applicant itself made any effort to obtain a contract with the builder.
The applicant worked entirely with Mr. Baird. through Mr. Baird, I should say.
And you say Mr. Baird is an employee of the
Yes, works for
owners?
the family, that's correct.
You made a statement to the effect that the owners examined the possibility of relocating the hot tub in the enclosure in a manner that might comply
Yes.
with applicable zoning requirements. Could you explain what was the restriction or other consideration that you concluded prevented relocation?
Primarily the cost. So to relocate the existing structure in a way that the structure could be used. The existing covered porch that's attached, there's an area of a covered porch that's attached to the exterior of the home in the backyard. And in order for this improvement to be functional and usable, that entire porch would have to be removed, as well as potentially certain existing paver areas as well, the cost of which it's not feasible for the applicant, especially after spending the amount of money they've already put into this project improvement and all the other improvements in their backyard. I will say, if you drive by the property, just another point, this is aesthetically appealing. I'll say too that the trees that are surrounding the edge of the property also shield the property from view. I know I personally drove by again this morning to take a look. You can't actually see the hot tub from the road, from your car, etc. It would have to be obviously an aerial view looking down. I would suggest to even be able to see what's going on in the backyard there.
We're actually not supposed to go look at these things before a
I
hearing.
understand, but of course, it's a small, I think it's a small community. I'm sure you know where the location is.
I'm familiar with the location.
I understand.
I'm not sure I understand your answer, though. I can see how that would be very disruptive to have to remove that back porch and so on, but what requirement would force that?
So, in order for the structure to comply with the code, the structure would have to be moved. And so, in order for the structure to be moved and to be functional, the existing improvements on site would have to be completely renovated, removed, etc. And the financial loss and hardship of that is the restriction here that would prevent the owners from being able to
Okay.
comply.
So it's not a specific setback requirement or
Well-
lot coverage requirement, or it's the cost?
Well, it's, yes, primarily the cost, but I would say that the lot coverage either way, as previously stated, the lot coverage has to be granted in order for, the other points become moot, right?
Right.
The real issue here is the lot coverage issue. And so anywhere else we put this structure on the lot also would still necessitate that lot coverage requirement.
Okay. All right. I have no further questions.
Thanks.
No, I don't, but thank you.
You're welcome. Thank you.
As a follow-up on the question of, or the answer that this hot tubs are prevalent in the community, and I agree with that, but, I agree with that. But Susan, can you tell me if variances are required? Have you had any variance requirements for hot tubs in
No.
the community?
No.
Okay, and there probably are a lot of them in the community.
There are a reasonable amount, I would think. We check them for the location on the lot. Typically, you don't see them on a big deck like this either. I mean, somebody puts a hot tub down, I'm looking at a square footage of 8 by 8 to verify, and and that it cannot be in the setback.
Okay, next question. The two parking places that were required, probably in 2016, in order to build the house on 40% of the land, et cetera. That was a requirement back then. Has it disappeared as a result of this?
No, the requirement for parking is based on the number of bedrooms. And they provide that to me before getting the permit on how they are going to park, if they have, and I don't remember here how many parking spaces they were required to have, but my records show that the backyard was paved, or they put pavers there because they would drive in from the alley and be able to park at least 2 cars there, what were required. Because they have put trees all the way around, they can no longer access that area with a car. Whether they ever do or not, we would never know, but the requirement to have those spaces was part of the building permit.
And you're saying that would be resolved?
It already has been resolved. So the existing parking exists on the ground floor, garage floor, whatever you want to call it, underneath the dwelling itself, and then also in the front of the property.
So
And
you-
there's 10 spaces.
You have the 5
Not 10
parking
spaces.
places, eliminating the paved area in the back.
So that there's a total of 10 spaces in compliance with code requirements, yes. And we will be sure to confirm that with Mrs. Frederick.
Not 10 spaces, but okay. I don't know.
Okay, I'll pass now. I will look for more.
Okay.
I have a few questions. If this procedure to put the hot tub in was sort of along a more traditional path, meaning that the request for the variances came before
Ask
the
for permission, not
work,
forgiveness, sure.
What would have been the grounds for seeking the variances at that time?
I would say that even in that situation, we would meet the quick check criteria, which I see as controlling here for some of the similar reasons that I've set forth today. I would say that standard's, relatively flexible, and for very similar reasons, we would also meet the quick check criteria. Of course, though, the primary issue here, I would say, is of course that the cost, the injustice, the hardship, et cetera, that's in existence as a result of not applying for permits, et cetera, is something that's obviously unique to this request.
In looking at the quick, in the Supreme Court case,
Sure.
what would have been the exceptional practical difficulty for not being able to put a hot tub on the property? I'm just a little confused what that standard would be.
So when you're looking at that, it's where the requested, an exceptional practical difficulty exists, according to this Supreme Court case, quote, where the requested dimensional change is minimal and the harm to the applicant if the variance is denied will be greater than the probable effect on neighboring properties if the variance is granted. And I would say that there are no impacts, no known impacts to the neighbors here. The improvement is a normal improvement in character with the area. It's a small dimensional change. Again, a reasonable and normal improvement and on a property that is limited in developable area based off existing improvements.
So would that mean that anybody who wanted to put an accessory on their property, hot tub or any other kind of accessory, could justify doing that if they had a lot coverage issue because they wanted it and not
No, I
being
think
able to
that-
put it in would create that?
No, I think that every case is unique, and the standards, of course, you'd have to meet the criteria for that given case. The particular facts here obviously are different, but they're the facts that we're working with, and that's what happened. I mean, it was an honest mistake, and I will say in this particular case, there is an exceptional practical difficulty.
Well, I'm not talking about the facts as we have them now. I'm talking about if we didn't
Sure.
have that honest mistake and we were just coming in the first instance. I'm having.
It would certainly be a challenge to meet that particular criteria.
Okay. With respect to the issue of self-made exceptional problem here, are you aware of any precedent court precedent that would argue that you can have a self-made precedent and that should justify the variance?
There is actually recent case law that suggests that, and I can't recall the name of the case, but that a self-created hardship is not a determinative factor in denying a variance, for example.
But it could be a factor in also not granting the variance.
Yes, provided though that you're also weighing and considering holistically all of the criteria that are set before you that you have to consider. And I would say in this particular case, those criteria weigh in favor of approving the variances sought.
Okay, so in your view, this board could decide not to grant this variance because of
And-
the
Yes, and I'll say too, so there are two really situations in my practice where this comes up. As we've mentioned, there's a request for permission, and there's, of course, a situation like this where you're asking for forgiveness. There was an honest mistake here. This happens. The law allows for a deviation from the code in the form of the variance, provided that you meet the criteria that we've discussed here. The law has a solution. Now, I can't say that in all areas of the law, but in this particular situation, if you meet the criteria of the code, you should approve the variances.
Okay. Another question, with respect, you mentioned that you didn't have a contract with the builder. Do you think that there is a damage recourse against that builder despite the fact that there is no contract with the builder?
Probably.
So the fact that it's not in writing won't prohibit the owners from pursuing the builder for damages should the variance?
I mean, of course, that's not something that the owners want to
Well, I understand that.
entertain. I imagine, yes, there's a cause of action against that builder.
Okay, that's what I was.
And I'll say too, when you go back to, just bringing it back to your initial question about the self-created hardship, a property owner is relying on their professionals, of course, to take the necessary steps. And in this situation, of course, Mr. Baird, who's present in the room, as well as the contractor, didn't take those necessary steps.
No,
And
I
it's
understand that.
unfortunate, but it's the situation and why we're here.
No, and sometimes that doesn't,
It
you don't
happens.
get there, so. Okay, I get it, okay. When you, in your letter, when you analyze the four factors under the town's code, the first criteria said there were extraordinary and exceptional conditions pertaining to the particular lot. And then in your answer, you say that developable, can't say that word easily.
Developable.
It's a tough one. Area of the property is limited due to existing improvements.
Right.
As I read that, would that be true for anybody who wants to put a hot tub or any other accessory on their lot, but has reached because of the size of their house?
It could be.
So that's not
Necessarily unique to a
exceptional to
property.
that property, or is that true of any property?
Could be true to any property.
So it's not an exceptional issue for that property?
Not necessarily, however, in this particular situation, we're looking at a structure that was built that has created this exceptional practical difficulty issue on a lot that already is limited in size and has existing improvements that limit what the property owner could currently do in this situation.
Okay. And then my last question is under the fourth criteria in the town code. A variance if granted would not cause a substantial detriment to the public good. If these variances were requested or were granted, if others were to see that and move on to put other accessories, hot tubs, what have you, on their properties and then seek variances only if they were later discovered to have done so, would you consider that a harm to the public good?
No, I wouldn't. I would say this is something that happens more often than you think. There's a prescribed procedure in the code that allows for deviations from setback requirements and lot coverage, and provided that this particular case meets the criteria that's set forth not only in the code but also by the Delaware Supreme Court, then those variances should be granted. And in this case, I would also say that you have to look at the fact that there really is, I can't put to words, and maybe a member of the public will, but to date, I haven't seen anything that suggests that this particular improvement causes any harm to anybody. It's a hot tub and deck at the end of the day that's being used for personal use in the backyard. And yes, of course, the applicant, the property owner, et cetera, should have applied for permits, but they didn't.
I understand what you're saying, but I don't know if that's responsive to what I was asking. If in fact other property owners were to become aware of this, if this variance were granted, and they decide a possible course of action for them would be to just go ahead and put things on their property without seeking variances, if that were to happen, let's just assume that, would you consider that development to be a harm to the public good?
Yes, but for reasons actually Mr. Gordon stated in the last hearing, you have to take each case independently, and I don't think that this would set that type of precedent. If that particular property owner decided to make XYZ improvement, they would still have to go through and it was in violation of the code, they would still have to go through the required steps, which this property owner in this case has done. And the purpose of going through the process and seeing if you meet the criteria of the code is to look at, is there harm to the neighborhood? Is there harm to the public good, et cetera? And I would say that no, there isn't here. There certainly could be in other cases. In this particular case, there isn't.
Oh, okay. Thank you.
You're welcome.
I have nothing further.
Any other questions?
No, thank you.
Does anyone feel a need to ask Mr. Baird to testify?
The only thing that I would like to do is to ask Mr. Baird to confirm the statements I made on the record. So if he could be sworn and then confirm the statements I made on the record as
Certainly.
true, which is my standard practice.
Certainly.
Sure, thanks.
Bill Baird, 33219 Paradiso Greens, Ocean View, Delaware.
Thank you, sir. And do you swear or affirm that you will tell the truth in this proceeding?
I do.
Thank you.
Thank you. And the only question I have is, Mr. Baird, could you please confirm that the statements I made on the record were true? Of course, if they are not true, please correct the record now.
They were true.
Thank you. And that concludes our presentation.
Thank you very much. The board has received two emails in opposition. I believe that's the correct number?
Yes, sir.
Susan? Two emails in opposition to the proposed variances, requested variances. Are there any individuals who wish to testify now in opposition to this application? Okay. Again, do you have preference as to who goes first? Please state your name and address.
Jonathan Ruckteschell, 114 Maplewood Street.
Do you swear or affirm that you will tell the truth in this proceeding?
I do.
Thank you, sir. Please proceed.
Thank you. The requested variance here, I think the questioning from particularly Mr. McHugh regarding the relatively, this is a dangerous situation here. You know, they just went commando, hired an unlicensed contractor to build a clearly illegal structure in a clearly unbuildable portion of the lot. There's just no question about it. It's jammed up against the back corner of the lot in a place where you're not allowed to build. And they built a big old structure there. This is not, you know, a grandmother here in town who's been here forever, whose grandson came and put a little deck on the back and it encroaches on the setback. This is a sophisticated real estate investment company, right? If you look at the LLC, it's a real estate investment company here in Delaware. They bought a $3 million property, and it's not a secret that when you're going to do construction in Bethany Beach or other places, you pull a permit. That's just what's done. And if they tried to pull a permit for this, it wouldn't have been approved. They'd have to apply for a variance. And there's just no chance that this board would have proactively approved the variance to build a significant structure right on the edge of the property in a clearly unbuildable space. The justification for which is our house is so big, we've already used our entire buildable allowance. And so now we can't enjoy the rest of our property unless we get to cover more of the lot. Well, that's what lot coverage is about. Having a big house that uses up your building envelope is not a justification for saying, well, now I need a variance so that I can build another structure. Even if it was within the buildable envelope of this lot in terms of the setbacks. But it's not even close. It's right up against the corner. So putting everything else aside, this is not an innocent mistake by a naive owner. This is a real estate investment company that bought a $3 million property and then just did what it wanted. And when it was confronted about this, it sounds like it basically ignored Ms. Frederick until the very last second, and then finally responded by coming in and saying, well, this was just an innocent mistake. We relied on the builder. We relied on Mr. Baird. And the committee the board is exactly right. If there's a problem here, if there's a hardship here, it's the fault, and it's not the fault of the owner, and I think it is, then their recourse is against the builder. They hired somebody who did something illegal. If they relied on him, and there's going to be a cost, you get that back from the builder. I understand and I appreciate counsel saying, well, the family doesn't want to do that. Well, sure, right? But we don't want the rules to be flagrantly violated here in town. And to the extent that there was a suggestion that this doesn't affect the public good or that people don't really care, we do. We do care about this. It's clearly an illegal structure that was done completely commando. The variance should be denied. They should have to remove it.
Sir? Excuse me. Let me just confirm whether or not there are any questions. I
Of
do
course,
not
I
have any.
apologize.
No. I do not have any questions.
I do not. No question.
I do not.
Thank you very much.
Thank you.
Please state your name and address for the record.
Janie Switzer, 318 Wellington Parkway.
Thank you. And do you swear or affirm to tell the truth in this proceeding?
I do.
Thank you. Please proceed.
So I'm not only a local resident, I'm also a builder. And as far as I understand, in Delaware, a handshake is a contract. And people that are spending the money for that contract generally have more money than the person who's doing the work. To go to Maryland to hire somebody for whatever reasons, maybe it was cheaper, but maybe they couldn't find someone around here, but they did it. So one of the comments was the survey took a lot of time. Yeah, well, surveys can take a lot of time, but there are also a lot of other surveyors that are licensed in Delaware. So if you went to Maryland for a contractor, why didn't you go to Maryland for a surveyor to possibly get your survey earlier? It's not the town's fault that the owner spent $50,000 on Brazilian hardwood. Clearly there's an education there on what's good products and what are not good products. So saying this is an honest mistake is just, it's upsetting to me as a person, as a homeowner, as a builder. the trees that they have put up are not just, it's a wall. And they're the type of pine tree that grows very quickly, which is part of the point. And it's a wall already. And to that, it has to affect the neighbors and the character of the surrounding area. The owner lives in Ocean View. You'd have to live under a rock to not know you have to get a permit in this area. So it's just not fair to everyone else that follows the rules, regardless of how much money they have or not. This Mr. Michael, that was the contractor, it sounds like he does not have a business permit in Bethany Beach. He doesn't have a business permit in Delaware. He should be now on a list of contractors that are not allowed to do work in this town. Parking. I don't understand how there are 10 or 11 parking spaces on this property. I mean, I would love to have that explained to me. There is no parking in the back, and if there's parking underneath, there's not room for 8 cars under that house. 2, typically. I can't exactly speak to how many, but certainly not 6, 7, 8, 9, or 10 parking spaces. And there is a parking space standard. I believe it's 8 by 18, and correct me if I'm wrong. There's no way there's 10 parking spaces at hardly any houses in this town, and certainly not that one. And it's a beautiful home, but there are not 10 or 11 parking spaces. And the injustice here is not just, it's not to the homeowner. It's to the town code and the surrounding area and the neighbors. And this case is just, in my mind, not about quick checking a Supreme Court case. And I just find it insulting. That's all I have to say.
Okay, one moment, please. Sherwin, any questions?
No question.
None.
And I have none. Thank you very much. Please approach and
Thank you, Chair. I'll be very brief. I just wanted to correct 2 statements on the record. So first, with the respect to the man that spoke in opposition first, the property here is owned in an LLC. Many properties are owned in LLCs, also trusts. In the town of Bethany, it's a form of obvious protection. This particular property, I'm not sure if this is being implied or suggested, but it's not being rented. It's used for the family's personal use, and I just want to be clear about that point. And then second, I just want to confirm again, at issue here is not the contractor's liability. At issue here is whether or not we meet the criteria for the variances requested, and I believe that we've set forth reasons why we do in fact meet the criteria of the code. I want to thank you again for your time, and I'll conclude.
thank you very much. Are there any questions of council?
Not me.
Gentlemen? No.
Thank you.
Thank you. Okay. Do we need to take a break before we deliberate? No?
I don't think so.
Okay. Applicant seeks variances from section 425 zoning attachment 3, appendix 3, table of dimensional requirements for both rear and side setbacks and total lot coverage to allow a hot tub and what applicant describes as a deck enclosure constructed without a building permit and in violation of the code requirements to remain in place. Under section 425-105D of the town code, in considering this application, the board is directed to consider whether owing to special conditions, a literal enforcement of the provisions involved would result in an unnecessary hardship or exceptional practical difficulties. And the four standards are: first, extraordinary and exceptional conditions pertaining to the particular lot or structure in question. Applicant maintains that the fact that the developable area in the rear of the house is limited due to the existing dwelling constitutes an extraordinary and exceptional condition pertaining to the lot in question. The lot is 40 feet by 125 feet, a typical size and shape in Bethany Beach, east of Route 1. It does not appear to me that the size of the backyard constitutes an extraordinary or exceptional condition pertaining to the lot. The lot survey shows the rear of the house to be 24.1 feet from the rear lot line, which is 4.1 feet deeper than the rear setback requirement of 20 feet. The second criterion, application of the code to this particular lot or structure, would create an injustice. Applicant argues that applying the code requirements to this lot and structure would create an injustice because it relied on the expertise and guidance of its professionals. If applicant's professionals had sought a building permit, which is a common requirement for improvements, or if they had reviewed the town's code, they would have been aware that the hot tub and deck they designed did not comply with the code's requirements. I think under the circumstances that denying the requested variances would not create an injustice. The conditions are peculiar to the particular piece of property involved. The applicant maintains that the hot tub and deck enclosure is peculiar to this property. The term conditions in this provision of the code, i.e. section 425-105-D1A3, refers back to 425-105-D1A1. In this instance, the condition alleged to be extraordinary and exceptional is that the developable area in the rear of the house is limited due to the dwelling. That condition is not peculiar to this lot. The third criterion is a variance, if granted, would not cause substantial detriment to the public good or impair the purpose or intent of the code. In my view, granting the variance would impair the purpose of the code. If the applicant's professionals had acted in accordance with well-known and common practices, this situation would not have occurred. Allowing the offending structure to remain undisturbed would condone disregard of code requirements. The board must also be mindful of the Delaware Supreme Court's holding, which applicant's counsel has addressed, the Quick Check case, that for an area variance, the focus is on the exceptional practical difficulties test. The first criterion of that test is the nature of the zone in which property lies. In this case, the variances are sought for improvements to a residence in a residential zone, so it appears that this standard is satisfied. The second criterion is that the character of the immediate vicinity, and uses contained therein. It does appear that the variances sought would allow improvements to a residence that would conform to the character of the immediate vicinity and uses. The third criterion is whether, if the setback restrictions were removed, it would seriously affect neighboring properties. The effect of granting the requested variances would be to allow significant encroachment into the code setback requirements, which would affect neighboring properties. In addition, granting the variance for maximum lot coverage would accept exceeding one of the code's most significant restrictions. And the final standard in the quick check case is whether, if the restriction is not removed, it would create exceptional practical difficulty for the owner to make normal improvements. And the decision states in this regard that the board should take into consideration whether, if the restriction upon applicant's property were removed, such removal would seriously affect neighboring property and uses, and whether, if the restriction is not removed, the restriction would create unnecessary hardship or exceptional practical difficulty for the owner in relation to his efforts to make normal improvements in the character of that use of the property, which is a permitted use. Applicant argues that an exceptional practical difficulty would exist because the dimensional change is minimal and it would suffer significant financial and loss of enjoyment harm if the requested variances are denied, which will be greater than any adverse effect on neighboring properties that would result from granting the variances. I do not believe that the cumulative effect of granting the requested variances would be minimal. The lot coverage variance from 40% to 44.6% in particular is significant in the overall context of this case and the intent of the code. Without that variance, it is my understanding that the requested side and rear setback variances would be in effect nullified. I think that the point is sound that the applicant does have resort to other means for recompense for the damages sustained in these circumstances, which also goes to the impact, in my mind, of the significant financial loss associated with the denial of the variance. So I'm inclined to vote against the variance. Sherwin?
Thank you, Mike. I'll be briefer. Briefer, is that a word?
Yes.
Shorter. The town building code is in place for a reason, and we're expected, all town property owners are expected to follow it. I consider not following those regulations in this case to be a harm to the town. And like you, Mike, I vote not to approve the variance.
Thank you. Jack?
I'm in agreement with your recommendations there. I don't think there's anything particularly exceptional about that lot because most of them east of Route 1 are that way. I think that the application of the code in this particular structure doesn't create an injustice because he should be able to be recompensed, as the chairman said, by the builder of this, whether he's licensed or not in the state of Delaware or a friend or not in the state of Delaware. And I do agree that this would harm our codes as they exist, because they exist in order to control this sort of thing unless there is a true variance. And this I don't consider a necessary variance, given what was initially established in 2016 when the house was built and 40% of the yard was supposed to be covered at the most, et cetera. So I go along with not approving the variance for those reasons.
Rich?
From my standpoint, looking first at the town's four components, I don't think the request for the variance satisfies any of the four. I won't go into the reasoning of that because it largely tracks, Mike, to your comments, but I would say that I'm particularly concerned about the impact this would have on the public good. If a variance of this sort were granted under these circumstances, it's very regrettable that we're in these circumstances, but we have to think of the larger good of the community in deciding this, and I think that would be very troublesome. With respect to the quick checks comments or standards, of the four, I think the more important are the last two, and I don't think the variance satisfies the standards set forth under either of those in this context as well. So, and again, for the reasons, Mike, you laid out earlier, so I also would decide not to grant the variance here, several variance requests here.
I guess that raised a question in my mind whether we need to act on the requested variances for the side setbacks, or we simply decide the coverage, the maximum lot coverage variance request. Which, what's your thought?
I mean, I don't know. If we could resolve the whole case today, it might be preferable to go ahead on all of them.
No, I'm prepared to go ahead with all of them. I'm just saying, if we deny the request for the variance on the lot coverage issue, that effectively nullifies the requested variances on the side setbacks. And therefore, I'm just questioning whether. All right, why don't we vote on all three then? And I will entertain a motion on our action as to this application.
I also move to deny the motion on all of these three variances.
Second.
We had a second by Sherwin, I think, first. All those in favor of the motion to deny the variances? Aye.
Aye.
Let the record show that all four members of the board voted aye. This final decision, approved by a majority of the board, is the official position, and there will, in likelihood, be a written decision issued. Appeals to the Superior Court must be made within 30 days of the filing of the final decision with the town. The board has 60 days from the conclusion of this hearing to issue a final decision. With that, at 12:35, this hearing is concluded. Thank you very much.